Senator Blackburn.
Thank you, Mr. Chairman. Amazing how our colleagues across the aisle are all about the rule of law and different things now when they chose to really just go rogue on so many issues during the Biden administration. Mr. Luther, I do want to come to you, and I want to return to this issue of the NDO. And I have found it being one of those that had my records subpoenaed. I have found it absolutely astounding that supposedly his basis for doing this was, and I'll quote, that notifying us would result in destruction of or tampering with evidence, intimidation, or potential witnesses, and seriously jeopardize the investigation. And of course, that is ridiculous on its face, that we would be there. So talk for a little bit about the unique nature of Judge Boasberg issuing the NDO on top of the subpoena.
Sure. So as I mentioned, he had a duty to make sure his gag order could be lawfully entered, and he failed to do so. And nevertheless, he entered this order with the provision that you just mentioned, signed there. On what basis? I think the committee needs to know what evidence he consulted to reach that conclusion. Senator Hirono, I know she just left, but she said it's not clear who's ultimately responsible and whether there's a cause of action for invoking this provision. Subsection D1B2 of 2 U.S.C. 6628 says that a private cause of action exists when Senate data was acquired, subpoenaed, searched, accessed, or disclosed pursuant to a search, seizure, or demand for information without notice being provided as required. So I don't know how much more clear the statute needs to be. When you all are not notified, there is a cause of action to be had.
Yeah. Talk for a little bit about your reference to the impeachment and resignation of Judge English. Yeah. In the 1920s, you said that this reminded you thought it was very similar in construction.
Sure. Well, I mean, certainly a lot has changed in the last 100 years, but Judge English had a number of charges against him. Contempt without lawful basis, which is the same as the situation with the Venezuela case with Judge Boasberg. Judge English was also apparently having some issues where he called in a number of government officials under the name of a fake case, the mayor, the sheriff, the county lawyer, and he just berated them, curse words, and then he sent them on his way. The use of the imaginary case reference is more of an analogy, but the reality is that, there was no case in Judge English's case. In this case, the Venezuelan individuals had already been removed, and the language that Judge Boasberg is saying his order contained is not actually the language in the order.
Okay, thank you. I want to move on with you to the speech and debate clause. We touched on that just a little bit earlier, and there was an email exchange. Mr. Chairman, I don't know if we have entered this into the record or not, but it's Wednesday, 17th of May, 2023 exchange between some of the attorneys, and I would ask that we submit this into the record.
Without objection, it will be admitted.
And this is from some of the public integrity section, and they acknowledge that there is some litigation risk in moving forward in the manner that they chose to go forward. And he makes the point that compelling the disclosure of the phone records would be a blatant violation of the speech and debate clause. So talk a little bit about the importance of that in this case.
Yes, I'm familiar with the email you're referring to. It is concerning. I mean, it shows that there's discussion amongst the special counsel's team that failing to disclose information about the individuals who are subject to subpoena could result in litigation risk, which I believe is the quote used, meaning that they could be found to have violated the Constitution or to have potentially engaged in misconduct. So, I don't believe, look, lawyers need to be able to have candid conversations about risk via email, but I think what that email does show is they knew there was a problem here, and yet at the end of the day, they didn't do anything about it.
Thank you, Mr. Chairman.